Tenure of office Osmina v. Kumlik. Facts: the petition calls for a determination of the validity and constitutionality of Republic Act 7056, an act providing for the national and local elections in 1992. Pave the way for synchronized and simultaneous elections beginning 1995, and authorizing appropriations therefor, which was signed into law on June 20, 1991. The suit was instituted by Governor Emilio M. Osmina, Gov. Roberto Pagdanganon on behalf of the League of Governors of the Philippines, Representatives Pablo P. Garcia, Raul V. Del Mar, Antonio T. Bacaltos, Wilfredo G. Cainglid, and Romeo Guanzon. By way of a petition for prohibition, mandamus, an injunction with temporary restraining order and/or preliminary injunction to prevent the implementation of said Republic Act 7056 and the consequent expenditure of public funds, and to compel the Kumlik to immediately end with all deliberate speed set up the machinery and make the necessary preparation for the holding of synchronized national and local elections on the second Monday of May, 1992. The petitioners claim they have actual and material legal interest in the subject matter of this case, not only because, as public officials, they have taken an oath to support and defend the Constitution, but also because, as taxpayers, they have an interest in seeing to it that public funds are properly and, more importantly, lawfully dispersed. They pray for this court to declare Republic Act No. 7056 as unconstitutional and, therefore, invalid and inoperative because, 1. Republic Act 7056 violates the mandate of the Constitution for the holding of synchronized national and local elections on the second Monday of May 1992. 2. Republic Act 7056, particularly the second paragraph of Section 3 thereof, providing that all incumbent provincial, city and municipal officials shall hold over beyond June 30, 1992 and shall serve until their successors shall have been duly elected and qualified, violates Section 2, Article 18 of the Constitution. 3. The same paragraph of Section 3 of Republic Act 7056, which in effect shortens the term or tenure of office of local officials to be elected on the second Monday of November, 1992, violates Section 8, Article X of the Constitution. 4. Section 8 of Republic Act 7056, providing for the campaign periods for presidential, vice presidential, and senatorial elections, violates the provision of Section 9, Article 9 under the title Commission on Elections of the Constitution. 5. The so-called many difficult if not insurmountable problems mentioned in Republic Act 7056 to synchronized national and local elections set by the Constitution on the second Monday of May, 1992, are not sufficient, much less valid justification for postponing the local elections to the second Monday of November 1992, and in the process violating the Constitution itself. If, at all, Congress can devise ways and means, within the parameters of the Constitution, to eliminate or at least minimize these problems, and if this, still, is not feasible, resort can be made to the self-correcting mechanism built in the Constitution for its amendment or revision. The Solicitor General prays for the denial of the petition on the ground that the question is political in nature and that the petitioners are merely asking for an advisory opinion from the court, there being no justiciable controversy for resolution. On the merits of the case, the Solicitor General contends that Republic Act 7056 is a valid exercise of legislative power by Congress and that the regular amending process prescribed by the Constitution does not apply to its transitory provisions. Issue 1. The court has competence to act on the matter at bar. Held yes ratio. What is involved here is the legality, not the wisdom of RA 7056. And even if we were to assume that the issue presented before us is political in nature, we would still not be precluded from resolving it under the expanded jurisdiction conferred upon us that now covers in proper cases even political questions, provided naturally, that the question is not solely and exclusively political but one which really necessitates a forthright determination of constitutionality, involving as it does a question of national importance. On the other procedural issues raised, we held as early as in the emergency power cases that where serious constitutional questions are involved, the transcendental importance to the public of these cases demands that they be settled promptly and definitely, brushing aside if we must, technicalities of procedure. It would appear undeniable, therefore, that before us is an appropriate invocation of our jurisdiction to prevent the enforcement of an alleged unconstitutional statute. We are left with no choice then, we must act on the matter. To summarize, on the procedural issue, we hold in view of the foregoing considerations, that the issue presented to us in the case at bar, is justiciable rather than political. Even if the question were political in nature, it would still come within our powers of review under the expanded jurisdiction conferred upon us by Article 8, Section 1 of the 1987 Constitution, which includes the authority to determine whether grave abuse of discretion amounting to excess or lack of jurisdiction has been committed by any branch or instrumentality of the government. As for the other alleged procedural flaws, lack of court standing, etc., assuming the existence of such flaws, the same may be brushed aside, conformably with existing doctrines so that the important constitutional issue raised may be addressed. Accordingly, we are left with no other alternative but to uphold the jurisdiction of the court over the present cases. It goes without saying that we do this not because the court is superior to the executive and/or legislative but simply because the executive, the legislative and this court are subject to the Constitution as the supreme law. Issue 1 RA 7056 is unconstitutional. Held yes ratio. It is evident from the wording of Article 18. Sections 2 and 5 of the 1987 Constitution that the term of synchronization is used synonymously as the phrase holding simultaneously, since this is the precise intent in terminating their office tenure on the same day or occasion. This common termination date will synchronize future elections to once every 3 years. That the election for senators, members of the House of Representatives and the local officials, under Sector 2, Art. 18, will have to be synchronized with the election for President and Vice President is likewise evident from the following records of the proceedings in the Constitutional Commission. It thus becomes very evident that the Constitution has mandated a synchronized national and local election prior to June 30, 1992, or more specifically as provided for in Article 18, Seconds 5 on the second Monday of May, 1992. On this point, it has to be stressed that the term of office of elective local officials, except barangay officials, is fixed by the Constitution at 3 years. The incumbent local officials were elected in January 1988. Therefore, their term would have expired on February 2, 1991. But their term was adjusted to expire at noon of June 30, 1992. The reason for the said adjustment, as well as those of the senators, members of the House of Representatives, President and Vice President, is the same: to synchronize the national and local elections. Upon the other hand, and contrary to the express mandate of the 1987 Constitution, RA 7056 provides for 2 separate elections in 1992 as follows: Seconds 2 start of synchronization. To start the process of synchronization of election in accordance with the policy hereinbefore declared, there shall be held an election for President and Vice President of the Philippines. 24 senators and all elective members of the House of Representatives on the second Monday of May, 1992, and an election of all provincial, city and municipal elective officials on the second Monday of November, 1992. The purpose of Republic Act 7056 is as stated in Section 1 thereof under the heading Statement of Policy. To start, as much as practicable, The synchronization of the elections so that the process can be completed in the 1995 elections, with the result that beginning 1995 there shall be only one simultaneous regular elections for national and local elective officials every 3 years. With the clear mandate of the 1987 Constitution to hold synchronized national and local elections in the second Monday of May, 1992. The inevitable conclusion would be that Republic Act 7056 is clearly violative of the Constitution because it provides for the holding of a desynchronized election. Stated differently, Republic Act 7056, particularly Sections 1 and 2 thereof, contravenes Article 18, Sections 2 and 5 of the 1987 Constitution. But this is not all. There are other provisions of the Constitution violated by RA 7056. For one, there is Section 2, Article 18 of the Constitution, which provides that the local official first elected under the Constitution shall serve until noon of June 30, 1992. But under Sections 3 of RA 7056, these incumbent local officials shall hold over beyond June 30, 1992 and shall serve until their successors shall have been duly elected and qualified. It has been held that it is not competent for the legislature to extend the term of officers by providing that they shall hold over until their successors are elected and qualified where the Constitution has in effect or by clear implication prescribed the term and when. The Constitution fixes the day on which the official term shall begin. There is no legislative authority to continue the office beyond that period, even though the successors fail to qualify with the time. If the local election will be held on the second Monday of November 1992 under RA 7056, those to be elected will be serving for only 2 years and 7 months, that is, from November 30, 1992 to June 30, 1995. Not 3 years as provided for by the Constitution. Then also, Section 9, Article 9 of the Constitution provides that, unless otherwise fixed by the Commission in special cases, the election period shall commence 90 days before the day of election and shall end 30 days thereafter. Under this provision, the filing of the certificate of candidacy and the ensuing campaign period must be embraced or circumscribed within that election period of 90 days, except when in special cases the cumulac alters the period. But RA 7056 provides for a different campaign period, as follows: Sector 8. For President arid Vice Presidential elections 130 days before the day of election. For senatorial elections, 90 days before the day of the election, and for the election of members of the House of Representatives and local elective provincial, city and municipal officials 45 days before the day of the elections. All these the postponement of the holding of a synchronized national and local election from 1992 to 1995, the holdover provision for incumbent local officials, the reduction of the term of office of local officials to be elected on the second Monday of November 1992 and the change in the campaign periods, are violative of the 1987 Constitution. The contention of the Solicitor General that the method of amendment or revision prescribed by the Constitution does not apply to the transitory provisions because in the nature of things transitory provisions are to be carried out as soon as practicable, and Congress can, in the exercise of its legislative power, enact the needed legislation. In this case RA 7056 deserves no consideration at all. The 1987 Constitution has stated in clear and categorical language that the 6-year term of the incumbent president and vice president elected in the February 7, 1986 election is, for purposes of synchronization of elections, hereby extended to noon of June 30, 1992. As discussed earlier, the elections referred to be synchronized with the election of the President and Vice President on the second Monday of May 1992, is the election for senators. Members of the House of Representatives and local officials. It is noteworthy that the Solicitor General evaded the issue of the constitutionality of RA 7056. Although he made a lengthy discussion on the procedural issues and on the legislative power of Congress, he failed to refute the arguments of the petitioners that RA 7056 violated several provisions of the 1987 Constitution, more importantly, the provision on synchronization of election.